So good afternoon, everyone, and welcome to this session of Estate Administration Week. We're so thrilled to have you join us today. My name is Noel Xavier, and I am the Director of Philanthropy and Donor Engagement here at Edmonton Community Foundation. The Edmonton Community Foundation, or ECF for short, has been presenting Estate Administration Week for a couple of years now in conjunction with our Wills Week, which we have presented every October for the past 20 years. We work with donors who build endowment funds to support the charitable sector and the causes that they most care about in our community. And as such, we deal with donors who are making plans in their estates through wills or life insurance, etc. And we have seen many cases where it's so important to have important information about effective and complete estate plans. And so that is why we put these sessions on for you, our community. We welcome volunteer lawyers who are experts in the field of estate law to present to you valuable information so that you can help make good decisions for yourselves and your families. And today we have a wonderful presentation from a lawyer that is no stranger to Edmonton Community Foundation. If you've attended any of our Wills Week or Estate Week sessions before, you've probably already had the chance to listen to her or meet her at one of our live sessions in previous years. Before I introduce our speaker, just a couple of quick housekeeping items. We will not be monitoring the chat. So if you've got a question for our presenter, please put it into the Q&A function. So again, do not put your questions in the chat, please, as we're not looking at that. We'll be looking at the Q&A section. For most of you, that should be at the bottom of your screen. For some of you, it might be down the side. So again, questions in the Q&A, and we'll get to those at the end of Jacklyn's presentation. The second housekeeping item before I introduce Jacklynn is to please ask you to please fill out the survey at the end. When we close the session, you will automatically be invited to fill out a survey about today's presentation. Filling it out helps provide valuable feedback to us at the Edmonton Community Foundation so that we can make these sessions better for coming years. So please do take a few minutes at the end to fill out your feedback. It's very important to us. Thank you so much. And now, without further ado, I am going to introduce our speaker. So excuse me while I just move her introduction so I don't miss anything. So as I said, no stranger to Edmonton Community Foundation. We're so thrilled to have Jacklynn Pivovar with us this afternoon. Jacklynn is a partner at Thomson LLP, and she's been practicing law for over 20 years. She practices exclusively in the area of wills and estates. Jacklynn has extensive experience in estate litigation matters, including complex disputes relating to wills, trusts, capacity, and other contested estate matters. She's also got experience in estate planning from conception and implementation of the estate plan to the eventual administration of the estate. Jacklynn has been recognized as a leading legal advisor for estates and personal tax planning and estate litigation by the Canadian Legal Expert Directory in 2023, and she was also noted as a Litigation Star 2023 in Benchmark Canada. In addition to being a wonderful volunteer for ECF, Jacklynn also holds a third-degree black belt in judo and is an instructor of judo. And so without further ado, I will turn the screen over to you, Jacklynn, for our presentation today. Thanks so much.
Perfect. Thanks so much for the introduction. Welcome, everyone. Today's topic that we're speaking about is beneficiaries not named in a will and an executor's guide. So the purpose of this is to give you a little bit of background as an executor and things to watch out for beneficiaries that you might not know about if they're not named in a will. So I'd like to start off by giving you a little bit of estate vocabulary in terms of information that I may be discussing during the presentation. The first, of course, is the difference between intestate versus testate. So an intestate estate means someone passes away and they do not have a will. And you would be applying for something called a grant of administration, and the person looking after the estate is often referred to as the administrator. Compare that to a person who dies with a will. That's considered they die testate. So they do have a will. You would be applying for something called a grant of probate, and the individual looking after the estate is often referred to as the executor. So I may refer to an administrator or an executor interchangeably as the personal representative. So if you hear me say personal representative, it's referring to either the administrator or the executor in either context. Now, a trustee, of course, may be the personal representative or someone else. Example, a parent, if there is a trust in a will. And of course, beneficiaries are the individuals who receive the assets of the estate. So who is a personal representative? Whether it's a will or not, generally you're looking for someone who'd be trustworthy, who's responsible, they're good with finances, and of course, good at communication, because they have to be communicating with all of the beneficiaries of the estate. And they have to be able to minimize and handle conflicts that might arise between the different beneficiaries. So if you have no will, again, someone who should be applying fits these criteria, or if you have a will and you're appointing someone in your will to be the personal representative, these are characteristics that you look for. Now, there can be more than one personal representative. It depends on the circumstances. It may be 1, 2, or 3 or more, depending on what the will says, or who may want to apply either jointly to be the executor/administrator of the estate. What are the general duties and responsibilities of the personal representative? Well, one of the first duties they look at is whether they need to apply for probate or grant of administration. They have to provide notice to the beneficiaries of the potential claim. They have to, of course, account to the beneficiaries and distribute the assets to the beneficiaries of the estate. The personal representative often handles non-estate assets. These includes things like insurance or registered designation plans, if they are payable to the estate, or finding out who may be the beneficiaries and giving them information with respect to that. The key question people always ask me is, well, if I'm appointed as a personal representative, do I have to do it? No, you don't necessarily have to do it. You can renounce your right to apply to be the executor of an estate. But you must do this before you start handling anything. So if you start intermeddling or you start doing actual acts that involve like the estate or dealing with the estate assets, you cannot be removed unless you get court approval to do so. So if you decide you do want to renounce and you haven't taken any steps, then it would go potentially to the alternate named in the will, or perhaps the next beneficiaries who by legislation may have priority to apply. So I don't have time today to go through all the circumstances of how the legislation works, but just to let you know that if you're appointed as a personal representative or you have priority to apply as the personal representative, you can decline to act and then it will go to the next person. So what happens if you have agreed and you are going to act as personal representative? Now what? Okay, so I always like to use the analogy to a game of Monopoly in this. So you've now agreed, now what do you have to do to play the game? So first question is, do you need to apply for a grant of probate or grant of administration? And that might depend on various facts. Sometimes you may not need to apply for grant of probate or grant of administration. So a good example of this is if between spouses, husband and wife, and all of the assets are joint and there's no assets in the estate. So all of the assets flow outside of the estate to the surviving spouse. So no grant of probate or grant of administration would be required in that circumstances. Sometimes there might be assets that form part of the estate, but again, a grant isn't required to transfer those. So the first question you need to ask yourself is, number one, are you appointed as the personal representative? And do you need to apply for that? A grant of probate or grant of administration is the process where the court actually certifies that the person appointed as the personal representative is the person with legal authority to act on behalf of the estate. There are many different forms to apply for a grant of probate, and there's two ways to do it now, by way of digital grant or by way of paper application for a grant. Digital grants for probate or administration can only be done if you are represented by legal counsel. Someone who is self-represented is not allowed to do a digital grant application. On average, if you're doing a digital grant application, it takes about 2 to 3 weeks to actually get a grant, versus if you are to do a paper application for a grant, it may take up to 3 months or more to actually get a grant of probate or grant of administration. Part of that application process includes submitting an inventory of the assets and liabilities of the estate. This is called the GA2 inventory of the estate, and these are values as of the date of death. So if you hear me talk about an inventory or assets of the estate, I'm referring to that inventory of the estate in the GA2. Of course, the application that you would be making includes notice to potential, what I call unnamed family members who have a potential claim against the estate. So as the personal representative, your job is to determine if there's any potential family members, or what I'm referring to in this presentation as unnamed beneficiaries, who need to be provided proper notice. So steps as the personal representative, we're going to go through these in each detail. If you have any questions, I ask that you put them in the question as noted before by Noel, and we'll get to your questions at the end, okay? So the first step as the personal representative, number one, locate the will. Is there a will or is there not? And is it a valid will? That's the first step you need to determine if you're going to apply for the grant of probate, to probate the last will, or the grant of administration if no will can be located. You have to obtain multiple copies of the death certificate because banks and other institutions may require this in addition to submitting it for insurance, etc. You want to review any marriage contacts or family law issues or family relief issues, again, as it relates to these potential beneficiaries we're going to talk about. We want to cancel identifying information and stop any payments like CPP or old age security, any payments that might be coming through. You have to put them on notice that the person is now deceased. Second part of that is determining who are the beneficiaries. Again, if they're named in the will, there's maybe two types: specific bequest beneficiaries or residuary beneficiaries. A specific bequest is when someone put in a will, for example, I give my diamond ring to Jane. So that's a specific bequest of a specific gift, and you have to identify who that beneficiary is. Similarly, a residue beneficiary, for example, the will might say, I leave the residue of my estate equally between my children. So that's everything else remaining in the estate after any specific bequest. So again, determining who those beneficiaries are and making sure you can put them on notice in the application process. So beneficiaries to consider who are not named in a will are often considered under our Family Maintenance and Support claimants, or under our Wills and Succession Act legislation. These are defined individuals in our act of who may have a potential claim against the estate if they're not named as a beneficiary or receive the whole of the estate. In addition, as an executor, you have to be aware of potential creditors, and of course the CRA, or Canada Revenue Agency, with respect to any taxes that are owing. So debts and taxes have to be paid first before any distribution of the estate can be made. So who are these potential family members? So again, our legislation allows that anyone in Alberta can draft a will to leave their estate to whoever they want. However, there is an exception to define members as family members under our legislation. Family members are potential claimants against the estate and have a potential claim to say that what they were left in the estate is not sufficient for their maintenance and support. So as a personal representative, you must be aware of potential family members and provide them proper notice, which is a GA3 form, to make sure that they are given notice of their potential claim against the estate. So this notice includes either a notice under the Family Property Act, a notice under our Wills and Succession Act, or any notice to potential dependents of the estate. With respect to our reference to monopoly, before monopoly, the family's all getting along while the person's alive, but unfortunately after death, I always see in estate litigation that this always kind of drives families apart, just like when we're playing Monopoly. So I like to use that little bit of analogy here. So who is a family member under our legislation, and who can make this potential claim against the estate? Again, this is defined in our legislation to include the following. So our spouse or adult interdependent partner. An adult interdependent partner is often considered someone who is in a common law relationship of at least 3 years, or there's an agreement, or they have a child of the relationship. So it's defined in our legislation of who an adult interdependent partner is, and you have to fit within that definition. I don't have time to go through all the specifics of that today, but there is defined legislation of who is an adult interdependent partner. It also includes a minor child, a child between the ages of 18 and 22 who are in full-time studies, a child who suffers from a mental or physical disability and unable to earn a livelihood. So that includes an adult child in those circumstances, or also a grandchild under the age of 18 whom the deceased stood in the place of a parent at the time of the deceased's death. So to give you a good example, something that went wrong, I once had a file where a personal representative had brought an application for a grant of probate and made the decision that he felt that the person living with the deceased at the time of his death was simply just the roommate and not the potential adult independent partner of the deceased, and did not give them notice and proceeded to distribute the estate. Of course, she then brought a claim against the estate, claiming she was the adult independent partner, and then he was personally liable for any amount that was owed to her because he failed to give her proper notice. So it's very important as an executor to determine whether or not these individuals fit within the definition and you want to give them proper notice. If you're not sure, what I always do is just make a note in the application process to say, it's your position they don't fit this definition of whether, say, it's an adult independent partner or someone who suffers from a disability. But then I advise that I just give them a courtesy copy of the application. That way, if someone does claim that they have a potential claim against the estate, it still gives them the possibility of putting them on notice. Now, a family maintenance and support claim against the estate has to be brought within 6 months of the grant of probate being issued. So that is a limitation period that's noted in our act, that if they're going to bring a claim against the estate, it must be 6 months from the date the grant is issued to file a claim. Now, again, family members do not automatically get an amount from the estate. They actually have to prove their claim. So they have to file a claim against the estate, claiming that they should be entitled to more of the estate than they otherwise received. So again, it's a right to make that application, does not mean that they will be successful. And there's a test in our legislation as well as our common law that has to be applied to determine whether or not additional money should be paid to these family members. The test, of course, is, did the deceased adequately provide for the proper maintenance and support of the family member in life and on death? So what does that mean? If we look to our legislation and our common law, it's kind of a two-part test. The first test is the legal obligations, and the second part of the test is the moral obligations. So the testator has to look, okay, what did I do during my life, and what has to continue after death? So the variation is determined based on a range of what society would consider appropriate in the circumstances. So every case is based on its own facts, and it's not a one-size-fits-all to determine whether or not a family maintenance and support claim should be brought. So legal obligations are different depending on who the family member might be. So for example, with a spouse, so they're married at the time of death, what would they have received or been entitled to on death at the time of, if they had just divorced just before the individual had died? So what would they have gotten if they had divorced? Similarly, for an adult independent partner, what would they have received if they had separated the day before the person died? So those claims are brought under both the Family Property Act as well as our unjust enrichment principles with respect to adult independent partner, depending on when the relationship may have ended. So those of you who do not know, a spouse and adult independent partner are both used under the legislation for Family Property Act versus under the old law prior to 2020, a spouse was only entitled to specific amounts under the Matrimonial Property Act, but that has changed for adult interdependent partners. So you have to be careful as an executor and make sure if you're aware of any potential spouse or adult interdependent partner. Now, of course, with respect to potential minor child, what would they receive for child support to make sure that they were properly looked after? So that's kind of the starting point for the test for family maintenance and support. In addition to that, we have to consider moral claims. So what is the moral obligation that the deceased would owe to the potential family member? And those obligations are found in society's reasonable expectations of what a person would do in the circumstances, given community standards. So there, again, are various factors to consider. This includes things like the size of the estate. Are there other potential claimants? Is there a spouse and minor children? What's the age and health of the potential claimant? What's the likelihood of their needs increasing? So for example, if you have an estate where the family member is a disabled child, what's the likelihood of their needs going to be increasing over time? So should they get a larger share of the estate? What are their contributions to the estate? What did they bring to the relationship? Was one person a stay-at-home parent and one person just bringing in the income for the family? So again, what did they do to contribute? And again, it considers non-financial contributions. Were there gifts outside of the will? So say, for example, are there RSPs or is there life insurance that the individual might have received outside of the estate? What is the length of marriage, etc. There's a non-exhaustive list of factors to consider. And again, those are included both in legislation, and there's also common law factors to consider. And I don't have time to go through them all today, but each case, again, is determined on its own facts. Just as an example, in terms of a family maintenance and support claim of a spouse, it'll be treated much differently if it's a 1-year relationship versus a 40-year relationship, or if there's a blended family and there's other children or claimants involved in the estate. So your job as the executor is to make sure, hey, is there any potential family members? Make sure they're put on notice. And if they are on notice, have they brought a claim against the estate? So a family member who brings a claim against the estate within those 6 months, your job as the executor is you're not allowed to distribute the estate until either that claim has been settled or there's a court order with respect to the distribution of the estate. So if the claim is brought, you're prevented from distributing any of the estate until that claim is dealt with. So it's a very important factor for you to know as an executor of the estate, not to distribute the estate until that has been dealt with. Moving on from family maintenance and support claim is, of course, your duty to safeguard the assets of the estate. So gathering in the assets, once you've determined who the beneficiaries are, giving notice to the family maintenance and support claims. You've got now a grant, then you can open an estate account, you can notify the banks and institutions. And again, just as I noted here, don't make any distributions until the expiry of either the limitation period or the FMS claim is approved by the court. So valuing the estate assets, again, in the inventory that we spoke about earlier, the estate assets will be valued as of the date of death. So part of your job in the application process is to find out, okay, what are all of these assets worth? If you're applying for a digital grant, it's very important to gather the information as much as possible and as soon as possible, because you have a very short limitation period to then advise the court if there's any additional assets. So you want to try to avoid listing any assets as to be determined in your application for the grant, because you have to file an updated inventory within 6 months. And sometimes, depending if it's complicated assets, such as a corporation, or maybe there's some other foreign property that you don't know what those assets are, you want to avoid having to update that inventory in the 6 months, because if you don't update the values as to be determined, a court application may be required to advise the court why you can't put all the values of the inventory in your application. Of course, your job is also to apply and collect death benefits. For example, the Canadian death benefit. You can apply for and collect life insurance and other insurance benefits that are payable to the estate. Again, your job is to investigate any debts owed, and we're going to talk about how you can advertise for creditors instead, to make sure that all the debts have come forward. Of course, determining the value of that estate, and then assess any family maintenance and support claims. So in the terms of the administrating the estate, one of the first things you want to do after you get a grant, or potentially before, is to advertise for creditors. This way you can make sure that there's any creditors for the estate have come forward, because as an executor, if you pay creditors without having sufficient assets, you can be personally liable for the amount that you've distributed from the estate. So again, advertise for creditors, make sure those creditors are paid. If you don't agree with a claim, so say, for example, a family member says, hey, I'm owed $10,000 and I need that to be paid from the estate, and you disagree that that amount was owed, you can serve them with a notice of contestation, getting them to prove their potential claim against the estate. As an executor, you want to be aware of the marshalling rules. Again, you want to make sure if there's insufficient assets to cover the debts of the estate, that you're distributing the estates in accordance with the rules for marshalling, i.e. Who gets paid first, funeral and estate expenses, secured debts, unsecured debts, and the residue or specific bequests. You want to make sure that they're paid in proper order, and be careful in applying for an estate that might not have sufficient assets. So how do we advertise for creditors? Well, in the case of an estate that has less than $100,000, you can put a notice to claimants in the newspaper, for example, only once. If it's a value of the estate is more than 100,000, then that notice to creditors should be in the paper at least twice. And then the claimant has 30 days after the date which the notice is published in order to notify you of his or her potential claim. So I'm always asked, well, what does this advertisement look like? And a lot of you have probably seen them in the newspapers. And usually we pick the newspaper in the jurisdiction where the testator had died. So for example, if they're living in Edmonton and they died in Edmonton, we would obviously choose one of our Edmonton papers. Maybe that's the Edmonton Journal or the Edmonton Sun, one of those papers to advertise for creditors. So this is a sample of the notice to creditors that you would put in the paper. Again, it's just a sample, but I'm giving it to you just for reference. It's called a GA15, where you're putting on notice the creditors. So if you look at this, the estate of, and you insert the estate name, who died, and then you insert the deceased death. If you have a claim against the estate, you must file a claim. And again, this is the note of the 30 days that you put in your notice publication, depending on your publication date. Information about yourself for the personal representative or the lawyer who's acting on your behalf, and of course your address where they can send the notice to. So again, this is something you often see in the papers. I encourage you to look at the paper to see if you see anything in there, and it'll give you a better idea of how to do a notice to creditor. Assuming that you've done the advertisement for creditors, then as the executor of the estate, then you would want to get what's called a statutory declaration of publication. This is the GA16 form, where it's a declaration confirming that you've done the advertisement. So this is something that I keep on my files just to confirm that, hey, we've done all of the notices to the creditors, if there's creditors come forward or not. This is proof that the notice has been done. Now, unfortunately, with the digital service, these no longer are filed. But if it is a paper file, i.e. it wasn't done digitally, these can actually be filed with the court. So that puts me on notice, and puts other members who are researching the estate that the notice has been put out. So the other job of the executor or a potential unnamed beneficiary, of course, is dealing with taxes. Now, personal representative files the tax returns on behalf of the deceased. And it's very important you talk to your tax advisors and your accountants with respect to making sure all proper tax returns for an estate have been completed. You should obtain a copy of the last tax return filed by the deceased and complete and file any outstanding tax returns. And of course, there may be separate trust returns to be filed on a go-forward basis for the estate if the estate is continuing to earn income or other has not been distributed after the terminal tax return has been filed. So again, recommend speaking to your accountant with respect to what tax returns, if any, need to be filed. And of course, as an executor, I highly recommend you getting something called a tax clearance certificate from Revenue Canada to confirm that all taxes have been filed on behalf of the estate prior to doing any distributions. Because again, unfortunately, if you make distributions and taxes are reassessed or owing, you can be personally liable. There was a recent case that came out where the personal representative had distributed the estate, and unfortunately, CRA did a reassessment and they said, oh no, you actually owe us $100,000 more, but the executor had distributed the estate. He brought a claim against the beneficiaries to recover that, but the court indicated that the executor was the one responsible for that. So when you're dealing with estate administration, again, I always recommend speaking to your advisors, speaking to an accountant, and doing a sufficient holdback to make sure that there's enough money to cover any potential tax liabilities until you get the final clearance certificate. So people always say, well, what is a clearance certificate? I've never heard of this before. Well, this is a sample one just for you to look at, because I always think it's a good to have an example. And if you see on this document, there's 3 types of clearance certificates you can get. So the first one is to the date of death. So this confirms from Canada Revenue Agency that all taxes are filed up to the date of death. So that confirms that any taxes that might be owing have been paid, and CRA confirms that. The next one is if you're doing an interim distribution, perhaps the trust, but you're distributing some of the money before you get a final clearance for final distribution, so that you may request an interim distribution clearance, and of course for final distribution. So sometimes people apply for each one separately. Sometimes they apply for them all at the same time. But again, before making any distributions, I recommend getting this clearance certificate from Revenue Canada to make sure that all taxes have been paid and there's no possibility that CRA might do a reassessment and say, hey, there's additional taxes owing. Because again, CRA, although they're not listed in the will, all know two things are certain: death and taxes, and so those have to be paid. So in terms of the distribution of the estate, we've went through the first two already in detail, as well as the family maintenance and support claims. So debts are paid, clearance certificates received, maintenance and support claims have either been settled or the limitation period is expired, i.e. you're beyond the 6 months from the grant issuing. And of course, you can proceed with distributing the specific bequests. The example I gave earlier was the diamond ring, or perhaps a cash bequest like $5,000 to a grandchild. You can start doing that. In terms of before distributing the residue of the estate, you want to make sure you do an accounting and proposed compensation that the beneficiaries would then approve. So unfortunately, in this situation, I always recommend that you get a release from any of the beneficiaries who are residuary beneficiaries to make sure that they've reviewed everything you've done and they're satisfied with the work that you have done. Personal representative compensation, again, has to be approved by the beneficiaries. And if there is no agreement, you can apply to the court to do so. Similarly, if the beneficiaries are not agreeable to the accounting you provided, as an executor, you can apply to the court to pass your accounts. So in finalizing the estate, you want to prepare and obtain those releases from the beneficiary. The form that we use is called an ACC 12 release. So that confirms, you've provided the financial statements to the beneficiaries, they've approved it, and they are approving the financial statements that you've provided and any proposed compensation. If the beneficiaries do not approve it, again, you can apply to the court to pass your accounts and say to the court, okay, here's everything that I've done. Court, will you approve everything that I've done? Because the beneficiaries will not. And then again, they can also seek approval of that compensation if you cannot agree on the amount of compensation to be paid. And a compensation, again, is determined on each fact. So for example, a will might specify what the compensation might be. And if not, then you look to the general principles of what that compensation should be in terms of case law and the guidelines that are out. It's not a set amount, it is a sliding scale, and it depends on the value of the estate. So finally, as the personal representative, I like to use the analogy again back to the Monopoly game is go to jail, go directly to jail, do not pass go, do not collect 200. I'm over-exaggerating, obviously, with respect to going to jail. But again, it's important for you to recognize that as a personal representative, you can be personally liable if you are not acting properly with respect to the estate administration. So again, using the example of CRA, if you've distributed the estate and have not paid the taxes, you can be liable for up to the amount of the distribution. You can be liable for distributing assets to others who are not entitled to it. So a good example of this is the testator had told the executor before the death, well, I want my car to go to my grandchild, but the will provides the estate is divided only between the children. So if you distributed that car to the grandchild, then the children can say you weren't supposed to do that, and that should be an asset of the estate. So again, making sure you're following the terms of the will and who the beneficiaries are. Making sure to pay debts in order, i.e. secured debts versus unsecured, making sure that they're all paid in accordance with the marshalling rules if there's insufficient assets to pay those debts. Again, making sure you advertise for creditors. If you don't, the creditor comes forward later, you can be personally liable if you've distributed the estate without paying that creditor. And of course, making sure to act in accordance with the standard of care required as the personal representative. And making sure, example, if there's a charity in a state, that you make sure that those gifts are provided within a certain period of time. And we don't have a lot of time to go through with respect to charitable gifts, but I know working with the Edmonton Community Foundation, this is very important, and they're very knowledgeable of how, number one, you can save taxes to the state and how you can leave a legacy for your family. So I encourage you to speak to Noel with respect to, if that's something you're interested, to leave a gift of charity in your will. So if you're ever uncertain as an executor with respect to the estate, it's highly recommended that you, number one, obtain independent legal advice so that you can say, okay, well, I've spoken to a lawyer, I know what my obligations are. If you're uncertain, again, you can have a family maintenance and support claim approved by court order. So to again make sure that you as the executor are doing what you're supposed to do, not preferring one beneficiary over another. You can consider an advice and direction application to the court if you're ever unsure of anything, even if it's to pay out the creditors of the estate and you're not sure if there's a sufficient assets. So you can apply to the court to rubber stamp what it is you're doing. And again, if you're not sure that a creditor should be paid, for example, you can serve that notice of contestation that I mentioned earlier, which is the C11. So there's various options that you can consider if you're ever uncertain to make sure that you're doing what you should as the executor of the estate. So I know I went through this very quickly and hopefully I answer any questions that you may have. So I'll turn it back over to Noel to ask any questions.
Hi, I'm here. I just forgot to turn my mic back on. Hold on. Now let me turn myself on. There we go. Thank you very much, Jacklyn, for that. I know we've got a couple of questions, so just a reminder to folks to please put their questions in the Q&A. So can you tell us a little bit about any issues around not including estranged adults without disabilities in your estate plans?
So estranged adults are different, right? So if the person is estranged and they don't fit the definition of a family member, you are not required to give them notice in Alberta. So I'm focusing on that because the laws are different in other jurisdictions. So in Alberta, a family member, i.e. an adult child, has to be provided notice if they suffer from a physical or mental disability where they're unable to earn a livelihood. Now you have to be able to swear to that and in your application. So if the person is truly estranged and you haven't had contact with them for years, how do you know that they may or may not have a disability? So that's number one. Like how can you swear to that if they're estranged? So you want to double check to make sure, because you don't want it to come down later on. Now, if the person has assets in other jurisdictions, so for example, the testator has assets in British Columbia. Now, an adult child in British Columbia can bring a claim for what we call maintenance and support in that jurisdiction, whether or not they have a disability, physical or mental. So you really have to be careful. It's not just, okay, they're estranged, so I don't have to give them any notice. That's not the case. Number one, confirm, do they have a disability or not in Alberta? Number two, where are the assets located? Because every jurisdiction is different. An adult child can bring a claim against the estate in other jurisdictions, and I don't have time to go through all of them, but you want to double check which jurisdiction you're in. I use BC as an example because a lot of our clients and testators have assets in that jurisdiction, because i.e. the family cottage is in BC, so that one often comes up that they're not aware, different legislation applies. So
great. And if the adult child does not have a disability here in Alberta?
So again, depending on the definition, because remember, a child includes between the ages of 18 and 22 who are in full-time school. So they're still an adult in full-time school. They still have to be provided notice. So again, we have to look to that definition. Assuming they don't fit within any of those definitions, then they would not have to be provided notice with respect to the grant application.
Great. Okay, great. Thank you. In terms of family support, do foster children with permanent placement have a claim?
So the definition, of course, is a child of the deceased. So unless they are generally adopted, they will not fit the definition. So stepchildren, for example, it's easier for me to say because a stepchild does not fit the definition, right? They're not a child of the deceased. So assuming that the foster child isn't formally adopted, then they don't fit the definition, right? So that's how it works. So it's a grandchild. As mentioned before, there's a potential grandchild if you're standing in the place of the parent, an actual child who's a biological child, or a child between the ages of 18 and 22. Now, I can tell you that the legislators are re-looking at this right? Currently, the definition is biological, but it may change. But right now, it's biological / adopted, because that's considered a
/ adopted, but
yeah.
not foster. Right. Okay, great. Not necessarily about beneficiaries not in the will, but one of our listeners is asking to speak about insolvent estates. How are they handled?
So from my perspective, I usually, if a client comes to me knowing that an estate is insolvent, I usually recommend do not take on the role as the executor of the estate, right? You want to stay away from that. Creditors can come forward and actually administer an estate themselves. You don't want to start acting in an estate that is potentially insolvent. That's usually what I recommend, is try to stay away, because you don't want to open yourself up for potential liability, right? But sometimes you might start administering the estate and then realize after the fact that there's insufficient assets. And again, that's where you might want to apply to the court for advice and direction of exactly how to, I'll call it, distribute the estate. I know there was a recent decision with respect to exactly that happening, because there was several creditors involved in an estate, one of them being CRA. And in this case, the executor was seeking to prorate all of the assets of the estate between the various creditors. But CRA took the position that they had a priority creditor over the others. And so they were seeking the whole of the estate based on their legislation. So again, you want to make sure to get proper advice if you're not sure how to proceed. And again, funeral and estate expenses, legal fees relating to administration of the estate are usually considered a priority. But I usually tell clients, stay away from the bankrupt estates because it's a headache.
Okay, sounds great. If a codicil is written eliminating a family member from the will, can it be contested?
Sorry, so the question was, if there's a codicil eliminating
family member from the will. So the fact that the question has been eliminating, I'm going to assume the family member was originally in the will, because now the codicil is eliminating the family member. Can it be
Sure.
contested?
So
and to the person that asked that question, if I got that wrong, please type it into the Q&A and I'll re-ask
sure,
it.
I'll try to answer that. So a will or a codicil can be contested if someone's left in or out, and there's various reasons to contest a will or codicil. Whether you're successful or not, that's different. So just because a family member was in a prior will and now not in the codicil doesn't mean you can contest it. You have to have valid reasons to do so. So for example, family members defined in the legislation that we've discussed today, so the spouse, adult, independent partner, a minor child, etc., the definitions that I went through during my presentation, they have the ability to claim for family maintenance and support, as we've discussed, whether or not they're included in a will or a codicil. However, maybe there's other reasons you contest a will as an adult child or another beneficiary. Maybe, for example, the person didn't have capacity to sign the codicil. Maybe there was possibility of undue influence. So again, these things can be challenged. And actually, I have done presentations for Edmonton Community Foundation, I believe in our spring session, which was exactly that, like how estate disputes arise and how to avoid them. And I did speak about exactly this, as capacity, undue influence, potential claims against the estate that can be brought separate and apart from family maintenance and support claims. So today's focus was on, quote, beneficiaries not named in the will and your duties as executor, but you might want to have a look at Edmonton Community Foundation's webpage, because I know that they likely have a link to that presentation, which might be helpful.
And you're absolutely right. We do. Thank you for that plug. So you're right. There are lots of topics that we present throughout the different years, so that we're not always doing the same thing. We want to keep things interesting for you, our listeners and attendees. So feel free to go on to our website at www.ecfoundation.org. Currently, we have the new web videos, but you can go on to our YouTube channel, which is where all of the videos are held. So if you go to YouTube and type in Edmonton Community Foundation, you'll be able to see dozens and dozens of videos over the past years, and you'll be able to see Jacklyn's previous videos. So I encourage you to do that. So YouTube, Edmonton Community Foundation, or for newer videos, our website. Thanks, Jacklynn, for that plug. Okay, we've got another couple of questions here, actually. This is a longish answer, but a basic question, but it's looks like there's a child living in the US, and it's actually a three-part question. So I know that we always get lots of questions every year about executors outside of the Alberta jurisdiction. So why don't I'll do the three parts separately. So let's talk about appointing a child as an executor in the US, but I know you could speak to BC or Ontario as well.
Yeah, so depending on the circumstances, usually when you're appointing an executor, our preference is to have someone who's an Alberta resident, right? So that is the preference, but it doesn't always happen in every case. The concern would be is if you're appointing an executor outside of Canada or even outside of Alberta, is whether or not you have to then post a bond. Our courts require a bond to be posted for the grant of administration or grant of probate to be applied for. So you have to be wary of that bond would be posted. In addition, there might be some tax consequences. So if you have, for example, a non-Canadian resident appointed in a will and there's trusts involved, the concern would be that there might be tax implications with respect to that. Again, very important you speak to your tax advisors. And I believe Michelle Coleman from MMP recently did a presentation for Edmonton Community Foundation earlier this week on this exact topic. So again, another plug for Edmonton Community Foundation. They'll be posting that video soon about this topic. So
yep, that was on Tuesday, I believe. So if it's not already up on our website, it will be shortly, as will this one. Someone earlier asked, and I just responded privately. This session is being recorded. And so all of the sessions that are being recorded this week will be on our website. Give us a week or two for some editing, and then you'll be able to check in. And we encourage you to share the video links with your family and friends. So thank you for that. Okay, the second part of that question was, can I leave everything to only one child who would distribute it as desired or as dictated in the will? So I think this one is about is not including other children. It says, can I leave everything to only one child who would distribute it as desired or as dictated in the will?
So my recommendation is obviously to speak to your advisors in terms of how to set up your estate plan. The concern would be is whoever you've noted as your beneficiary, if you don't have it properly documented, for example, if there's a trust or notes in terms of where it should go, the concern would be that someone could contest it, obviously, that they should have been a beneficiary. They meant to be, I'm supposed to be included. And I'll give you a good example of this situation where the testator had left all of his estate to the named executor that he had noted in his will. And he had actually transferred his house, his property, into joint tenancy with the named executor. Unfortunately, the executor who he named took the position that it was all to him, rather than to the people that the testator told him where it was supposed to go. So he was trying to, quote, avoid probate by naming his executor on all of these, assets, so his RSPs, and adding his name to title to the house, because he wanted to avoid probate. Unfortunately, in the circumstances when the individual died, the personal representative name said, well, I'm the sole beneficiary of all of those accounts. I'm the surviving joint tenant on that house, so everything belongs to me. So that required me as a state litigator to apply to the court for an urgent application to, number one, prevent the sale of the house. Number two, to have the executor removed because he wasn't acting in accordance with the instructions that were left to the executor. And of course, the issue of the evidence, what is true, what was written versus what was told. So again, it's very important to properly document it. In this case, the will was very clear that the executor the testator was clear that the executor was to distribute his estate between 3 beneficiaries. And there was a lot of evidence saying that the only reason that it was in joint tenancy was for the purposes to avoid probate. So it was not intended to go by survivorship. And again, that is a topic for another day about joint tenancy and why you should or should not do so. We want to make sure it's properly documented, and that's a topic for another day. However, we recommend making sure that it is properly documented and don't leave it to someone's discretion, because that leads to litigation. So if you want intended beneficiaries, make sure that they're named, because in my case, we had to bring these court applications and sue the individual to stop them from doing what they shouldn't have been doing. So.
Great, thank you. And I think actually in our maybe 2 or 3 questions ago, you answered this one already, but is the child from a former marriage who's adopted in a new marriage entitled to anything? That child's now over 40 years old. I think we addressed this one a few minutes ago.
So yeah, the deceased have to have adopted the child, right? So depending on the circumstance, to be a beneficiary of the testator's estate, depending on the circumstances, right? So either they're named beneficiary or they fit the definition of the family member.
Yeah.
They have to be adopted. So.
Right. Excellent. Great. Thanks. If you're a co-executor with someone in another country and you wish to resign, can you do that?
Well, I guess the question is, are you talking about, is the estate here in Alberta or is the estate in the other country? So that's number one, because I can't comment obviously on
That's right.
other
Let's assume it's Alberta because we can't comment on other countries. Yeah.
Assuming it's Alberta and you've applied, you're already acting as the executor. So if you recall, I said, do you want to act or do you not want to act? So if you have not intermeddled in the estate, so you haven't done any steps as the executor, you can renounce to act as the executor. But if you have taken steps and you have intermeddled in the estate, you can't simply renounce at that point. You have to be removed by court order. So it depends if you've actually started acting on the estate, if you can agree to step down or renounce at that point in time. So.
Great. And then our discussion about insolvent estates led to a couple of questions. And I think you've addressed most of them. But here's a question about dying intestate. So if someone has died intestate and a letter of administration has been obtained, what would be considered the costs of the administrator?
So I think what you're asking is what would be the compensation payable for the executor? Is that the correct?
I think so, yeah, because then it says later on that, yeah, that everything's been paid. So by a parent, for example, for a child that's passed away, and then would those costs be able to be paid back to the parent?
So the administration costs in terms of administering the estate are to be paid first before any distribution. So example, I might be a long-winded answer, but I want to make sure I understand the question. So the funeral costs, the administration fees, the legal fees, the accounting fees, like any debts that are to be paid from the estate. Separate and apart from that is the executor's compensation. So that also is to be paid with respect to an estate. And again, what that compensation is depends on the facts of each case, right? And it's not set amount. So if there's no will, so it's an intestacy here, you look to the guidelines of what that compensation would be and what is reasonable in the circumstances. So again, it's a sliding scale based on the value of the estate. And there's various factors to consider. Is there a trust or is there not? So we look to the guidelines, we look to the Trustee Act and the various factors that might be involved in the compensation. Again, I don't know if there's a trust involved or not. I'm assuming not, given if it's an intestacy. But again, you'd have to be able to calculate that. And again, if the beneficiaries are not approving your compensation, even if it's an administration, i.e. no will, you can apply to the court to approve your compensation of what you propose.
Sounds great. Thank you very much. Those are all the questions. So I will speak slowly for the next sentence or two. If anyone wants to throw in one last question in the Q&A, please do so. But I'm seeing nothing. Oh, someone typed quickly. All right. So this will be the last question then. If an estate is considered insolvent due to the deceased having individual debt in their own name, however, there were other assets that were held jointly that passed outside of the estate, can the joint holder or beneficiaries be liable?
So that, again, the assumption is the creditors can only go after what's in the estate. So if it flows outside of the estate, You can't necessarily go after those assets because it flows outside. However, if, for example, you purposely put estate assets trying to avoid creditors at the end, they can be potentially clawed back, right? So I can't answer that 100% completely, right? But there is that potential that if you're trying to purposely just avoid creditors, right? And like, were they insolvent or are they in a bankruptcy already? That I can't answer that necessarily, but again, usually the norm is creditors can only go after what's in the estate, but you can't purposely, the day before you die, transfer everything out to avoid the creditors. But there's a lot of assets that flow outside of the estate in the normal course. So, for example, life insurance or named beneficiaries or joint tenancy, right? So those kind of things often flow outside of the estate in the normal course.
Great. Excellent. Well, thank you very much for today, Jacklynn. Even though you and I have presented in the past, I always learn so much from you every time. And I'm sure that a lot of our listeners learned a lot today too. So thank you very much for volunteering your time to share your expertise with us today. Again, to everyone listening, thank you for joining us. Please remember to fill out your survey. When we log off, it'll automatically pop up. And a reminder again that this session was recorded, and so it will be available at www.ecfoundation.org, along with the other online sessions that we are presenting this week. There's another session tomorrow afternoon, so be sure to check in with that one. And with that, I will conclude the webinar and wish you all a very good day. And Jacklynn, thank you again.
Thank you
Bye-bye.
so much.